I hope that won't go through on the other side. Well, hello everyone, and
Hi.
welcome.
Thank you.
Welcome to this webinar. I welcome you on behalf of the ICCBA's Defense Committee, who is sponsoring and hosting this webinar. This webinar is on the ICC rules of evidence and techniques of cross-examination. As you may know, the ICCBA is the recognized bar association of the International Criminal Court for both defense practitioners and victims representatives. The ICCBA Defense Committee is the organ of the ICCBA that is mandated with, tasked with focusing on the interests of the accused and defense practitioners and defense teams at the ICC. My name is Dragan Dejan Ivetic, and I am the current chairperson of the Defense Committee, and today I will be acting as your moderator. Today we have a very informative webinar for you, and I'd like to just give you an introduction as to the format of the same before we move on to the speakers. We will be attempting to provide you with interesting perspectives from both common law and civil code or continental practitioners. And again, before we begin, each speaker, we have 5 speakers total. Each speaker will be presenting for approximately 15 or so minutes. And then at the conclusion of every presentation, we will open up the floor for questions and answers from you, the viewers. And again, we are both on Zoom and on YouTube. So if you do have a question, if you're on the Zoom side, you can use the raise hand function in Zoom, and that will alert me to the fact that you have a question, or you can type the question in chat, and I will be monitoring the chat, trying to make sure that all your questions are answered. And again, I remind you, if your Zoom link is unstable and you keep getting kicked out, then by all means switch over to the YouTube live stream, whose link is in the same email that you received with the Zoom link. So with that out of the way, now I'd like to move on to our first speaker. And that is Sarah Valduriz, who is one of my colleagues on the Defense Committee. Someone has their mic coming in loud. She's been practicing as an attorney since 2009, located in Paris and then in Versailles, France. Her practice consists of defending clients before French national courts, as well as international courts. Internationally, she is on the list of counsel before the IRMCT and the ICC. And so with that introduction, Sarah, I would ask you to take over the floor.
Thank you. My presentation will be focused on the law of evidence at the International Criminal Court, the ICC. So the judicial decisions must be based on facts established by evidence. This statement by the appeal chambers of the International Criminal Court underscores the importance placed on evidence by the judiciary. Like international and internationalized criminal tribunals, trials before the ICC are complex and lengthy due to the breadth of the alleged charges and the quantity and quality of evidence produced by the parties. For example, in the Natonga case, the chamber analyzed the testimony of more than 100 witnesses and nearly 1,800 other pieces of evidence. Before elaborating on the law of evidence before the ICC, I will go back to some essential notions. The International Criminal Court is the world's only permanent international court with a mandate to investigate and prosecute the crime of genocide, crimes against humanity, war crimes, and crime of aggression. The structure of the ICC procedure is marked by 3 distinct procedural phases: pretrial, trial, and appeal. And the pretrial phase may be subdivided in 2 phases: the investigation and the confirmation hearing. The end of the pretrial phase is marked by the decision of the prosecutor to bring formal charges or not at the close of the investigation. The decision not to proceed with the investigation is solely within the competence of the prosecutor. No confirmation by the pretrial chamber is needed. In an investigation, the Office of the Prosecutor, the OTP, gathers as much information as possible to uncover the truth about the alleged crime, as well as to determine who is most responsible. An investigation may include the collection of evidence, the interviewing of witnesses, victims, the analysis of financial transactions, etc. The OTP is legally required to take whatever steps are necessary to gather all evidence which is relevant to an alleged crime, including incriminating and exonerating evidence, at least in principle. Before trial starts, the prosecutor must disclose a great deal of evidence to the defense. This includes all the evidence the prosecutor intends to rely upon at trial, and any evidence which pretends to show the innocence of the accused, of which affects the credibility of prosecution evidence. Note that the ICC cannot act by its own because it does not have its own police force or independent enforcement powers. It cannot enter or obtain evidence in certain countries without the country's permission. Once evidence establishes reasonable ground to believe a person is responsible for an atrocity crime, the ICC prosecutor may request the pretrial chamber to issue a summons or arrest warrant. After an individual's initial appearance, the pretrial chamber must hold a hearing with a reasonable amount of time to confirm or dismiss the charges presented by the prosecutor. Pretrial chamber can either confirm the charges and send the case to the trial chamber. At this point, the individual becomes the accused, or dismiss the charges and set the individual free, or pause the hearing to request the prosecutor to produce additional evidence or change the charges with the evidence presented. If charges are dismissed, the ICC prosecutor could provide additional evidence later to convince the pretrial chamber to confirm the original charges. Alternatively, the ICC prosecutor can start the whole process over again with different charges. The trial chamber is required to conduct a fair and expeditious trial that protects the rights of the accused, victims, witnesses, and other involved. There is a presumption that trial session will be open to the public. The trial can take place in closed sessions where this is necessary to protect witnesses of the confidentiality of sensitive matters. The first step of a trial is to allow the Office of the Prosecutor to present its evidence to provide the accused guilt beyond a reasonable doubt. Defense lawyers are allowed to test the strength of the OTP evidence presented. Once the OTP's case is concluded, the defense can present their own evidence. The OTP is allowed to test the strength of the defense evidence. Victims are allowed to testify at trial. They can testify as witnesses called by the OTP and can also testify independently of the OTP. Representatives of victims are allowed to submit evidence to support or to demonstrate the unreliability of evidence presented by the OTP and the defense. They are also allowed to mark written and oral observation when the trial chambers allows them to do so. Once the trial is complete, the trial chamber will begin to deliberate in private and reach a guilty or not guilty verdict. The trial chamber delivers its verdict with writing justifications. The Office of the Prosecutor and the accused can appeal judgment of to the appeal chamber. The victim cannot appeal an acquittal, but they can only appeal an order for reparations. Now we come to the more practical part of my speech. The legal basis of the ICC's procedure are its foundational text, treaty, the stated, ICC or Rome stated, and the rule of procedure and evidence that you find on the ICC website. The stated defines the procedure of the court mainly in its part 5, entitled Investigation and Prosecution, and its part 6 on the trial. although the provisions of Part 1 on the exercise of the court's jurisdictions and on the admissibility of the cases are important, as is Part 9 of the state that deals with the cooperation between the court and the state parties. The state provisions are complemented by the rules of procedure and evidence and the regulations of the court. The rules of procedure and evidence spell out many procedural questions that were left to judge-made law under the regime of the ad hoc tribunals. And the rules of procedure and evidence of the ad hoc international criminal tribunals were the first international procedure and evidentiary codes ever adopted, and they have to be amended gradually. Under the ICC statutes, such judicial rulemaking is only marginally possible. Rules of the procedure and evidence may be proposed by the courts.
Sarah, I think we've lost your audio. Where are you? One moment, let me just check to see if I can do that on this end.
Okay. Oh, you had to confirm.
Yeah, something had happened on this side, it looks like. You're logged in twice. Okay,
Yes.
go ahead.
Okay. I lost everybody at which part, or I continue?
We lost about, I would say 20 seconds of your presentations, the last 20 seconds. You can rewind a minute even. We'll make
Okay.
room for it.
Did someone hear about the legal basis of the ICC procedure or not?
I think that was right around where we cut out.
Okay, so I'm going to start.
Mid-sentence.
That was the practical part of my speech. So, part 2, continue. So the legal basis of the ICC procedure. If my voice is cut, just make a sign because I see you, and I'll go back. The legal basis of the ICC procedure are its fundamental treaty, the stated, ICC or Rome stated, and the rules of procedure and evidence that you find on the ICC website. The stated defines the procedure of the courts mainly in Part 5 entitled Investigation and Prosecution, and it's Part 6 on the trial, although the provisions of Part 1 on the exercise of the court's jurisdictions and on the admissibility of cases are important, as is Part 9 of the state that deals with the cooperation between the court and the state parties. The state's provisions are complemented by the rules of procedure and evidence and the regulations of the court. The rules of procedure and evidence spells out many procedural questions that were left to judge-made law under the regime of the ad hoc tribunals. The rules of procedure and evidence of the ad hoc international criminal tribunals were the first international procedural and evidentiary codes ever adopted, and they had to be amended gradually. Under the ICC stated, and such judicial rulemaking is only marginally possible. The rules of the procedure and evidence may be proposed by the court, but must be adopted by the Assembly of States and therefore not by the judges themselves. So the court's evidence procedure is autonomous from state procedure. Rule 63.5 provides that the chambers shall not apply national law concerning evidence other than in accordance with Article 21. So the court's procedure under the ICC combines structural elements of the inquisitorial and the adversarial process. The adversarial model, exemplified by the American British system, assumes that the justice is best served by giving the prosecutor and the defense counsel primary responsibility for development and presentation of their own case. And this model, the judge is a neutral and detached magistrate whose function is to mediate and resolve the opposing parties' inevitable conflicts. In the inquisitorial model exemplified by the French and the German criminal justice system, the judge has primary responsibility. You lost me? Do you hear me? Okay, good, because I heard someone else. Okay, good. So the inquisitorial model, so exemplified by the French and the German criminal system, justice system, the judge has primary responsibility not only for determining the relevant facts, but also for gathering and eliciting those facts. The parties assist the judge in this task, but the role is only secondary and supportive. The ICC procedure is structured on the adversarial process model, but contains such substantial elements of the inquisitorial model that it yields a mixed process system. I'm going to explain. The stated follows the adversarial process model by allocating the task of investigation and actual trial to two different bodies. That is to say, the prosecutor and the court by its pretrial chamber. The main structural provision of the trial phase is contained in Article 64.8.b. And the procedure is adversarial in that the prosecutor and the accused, okay, I was just sure that you're still listening to me. The procedural, Procedural is adversarial in that the prosecutor and the accused control the proceedings, including the presentation of evidence at trial. The presiding judge of the trial chamber has the task of giving direction for the conduct of the proceeding. The state also follows the inquisitorial process model by the fact that the court does not examine the case in order to assess whether there is criminal responsibility, but it gives the court powers that preclude control of the parties over the fact and evidence. Chief among these is the power of the court to request the parties to provide additional evidence and the power of the court to block any evidentiary understandings of the parties. The state does expressly bar the prosecutor from the role of the incriminator. Aside from the obligation to investigate the exculpatory facts and evidence and the extensive disclosure obligation, the prosecution special role is also evidenced by the fact that the prosecutor may appeal a trial chamber decision of acquittal or conviction or against a sentence on its own behalf, no surprise, but also on the behalf of the accused. That is Article 81.1 and .2 of the statute. Bear in mind that the drafters of the ICC statute always wanted to create a truly mixed procedure, and they indeed succeeded in doing so. The statute is ambiguous on many legal points because of its science or the vocabulary adopted. So it seems preferable, as Fatou Bensouda, the former court prosecutor, has done, to consider the court system as a sui generis system. The emerging picture is that the accusational structure of the process in international criminal procedure was adopted by the drafters without effectively implementing specific technical consequences. And the frequent exceptions to the technical solutions implied by this theoretical model put the fairness of the system in constant tension. The price of the inconsistencies in the accusational structure in most cases seems to be paid by the defense, which is systematically disadvantaged from the disclosure phase, in which the prosecution has a structural advantage over the defense, as we saw at the beginning of the presentation. If we consider the admission of evidence faced, notwithstanding general accusational framework, the rules governing admissibility resemble the inquisitorial model law. The chamber have interpreted the state of the rules to give the judge the greatest discretion concerning which items of evidence can be admitted at trial, leaving no room for technical formalities in this area. This solution risks undermining the equality of arms between the prosecution and the defense. And note that the court's jurisprudence is not always uniform between the chambers, which could be resolved by a better collegiality of the judges. In conclusion, the ICC is unique. It has a sui generis system, and it has just turned 20 years old on July 1st, 2022. The best way to administer international criminal justice has not yet been found, but the ongoing judicial development of criteria for evaluating evidence is helping to create a real legal certainty for the ICC. While national systems are several hundred years old and have undergone numerous evolution, the same is and will be true for the ICC. The ICC's need time to harmonize the application of its procedural system, but hopefully not too much time. Thank you for your attention.
Thank you, Sarah. And as I said at the end of every speaker, at the end when we complete all 5 speakers, we'll have a question and answer session. So if you do have a question related to Sarah's presentation, keep it in mind or already type it in the chat. And then we'll move on to our next speaker, who's also another one of my colleagues from the Defense Committee, Jean Flam. Jean has been an attorney in Belgium practicing internationally since 1974. He is a co-founder of Avocats Sans Frontières, also known as Lawyers Without Borders. He's also a past Secretary General of the International Criminal Bar, and in addition to his elected position within the ICCBA. At the ICC, he has represented the accused Labanga, as well as one of the defendants in the Bemba 2 case. Additionally, he has represented accused before the ICTR and the IRMCT. He is on the list of counsel at the ICC, the STL, and the Kosovo Specialist Chambers, and has authored a chapter in the publication Defense Rights, International and European Developments. I invite you to give your attention to Jean. Jean, go ahead.
Yes, thank you, Dragan. I am going to try to give you a personal view about what a criminal trial should be and the role of defense in that criminal trial. I'm going to speak to you also briefly about the question of written evidence, and lastly, about the means offered to defense under the legal aid system to perform its duty. The fundamental right to a fair and full defense is for the trial what a free press means for democracy, in a nutshell. There is often a tendency to reduce what some call justice to the self-declared and unique truth of a judicial file. This is, in fact, a sad remainder of the centuries of the Inquisition, where accused people and witnesses were interrogated in absolute secrecy and tortured to make them speak the truth. The continental criminal legal system in Europe is still sadly called by some inquisitorial. Criminal investigations are kept secret in many countries there, and witnesses are interrogated by police. In the absence of defense, important investigation actions, such as visits to crime scenes, are performed without the defense. This results in criminal files, as described higher, presented by the prosecutor as the truth. But nothing seldom is what it looks like. In the process of conflicting truths, an independent and strong defense with full equality of arms can become a troublemaker with very few lovers. And yet, a strong and independent defense protected by a strong and independent bar association is the last rampart of democracy. There is no unique truth. There are many truths, as many as there are women and men in the world. A fair trial should be a moment of the ancient Greek concept of catharsis, purification, a moment of several truths, an endeavor of explanation which makes civilizations advance to reconciliation, which is only possible when all truths have been told. It is the essential obligation of defense to bring the individual truths of the accused. In this quest for the other truth, it will be of essential importance to try to frame the real origins of the conflict and the complicities, which are very often international. Prosecutors and even judges are very reluctant to go that way. Consequently, this burden, which can be dangerous, rests on defense. Defense, consequently, must be given the proper means to deliver this essential duty. The Rome Statute has endorsed the fundamental principle of a full defense by determining mostly as minimum guarantees what the contents of the rights of the accused are in full equality in Article 67. Sarah has very rightfully, and this is, we are speaking here about a mixed system where the legislators have tried to merge elements of common law and of continental law. Remarkable is that the duty of the investigating judge in our systems, the continental systems, where we have still mainly investigating judge, which are independent from the prosecutor, is the duty of exculpatory examination and investigation. This is also the duty of the ICC prosecutor. My experience with continental systems is that this duty of the investigating judge is very often ignored. And why is that so? It is so because once a suspect has been selected, even investigating judges come in a mechanism of accusation. The means are important, and as long as the case evolves, it becomes almost mandatory to have this suspect being declared as the accused. I fear that more so for a prosecutor, an international prosecutor, this duty of exculpatory evidence is often an illusion. This makes the defense more important than ever. The essential common law institute of cross-examinations, which is the other part of the mixture, what has been made of cross-examination of witnesses, has been luckily safeguarded, because in my opinion, it is the best way to find the truth. Oddly, cross-examination existed in Roman law and does not exist as such in continental law. The main role for interrogation and cross-examination, if we call it that way, of witnesses in our law is given to the judge. Theoretically, even the lawyer must ask his questions through the judge, which results in, other questions very often. So the court also, very importantly, and this again then comes from the continental law, has the authority to request the submission of all evidence which is considered essential for the determination of the truth, Article 69(3) of the Rome Statute. Written evidence is consequently admissible, and the Chamber has very broad powers in ruling about the relevance or admissibility of this kind of evidence, as Sarah said very rightfully, as is the case in Roman German law as well. The main Article 69(4) of the Rome Statute, the main criterion here is twofold: the probative value of the evidence and any prejudice that such evidence may cause to a fair trial or to a fair evaluation of the testimony of a witness. The second part of the last criterion seems to me dangerous, as it may tend to grant a priority to witness statements, which would be very wrong. Witness statements are by nature subjective, and two witnesses may very well give conflicting statements about the same facts they both witnessed. There should be no hierarchy between written evidence and witness statements. It should be equally regretted that there are no general legal guidelines provided for evaluation of written evidence. To leave the evaluation of its probative value entirely to the judges seems to me as opening a door to possible bias, which is not necessarily conscious. The fact of the matter is, however, that legislators are always very reluctant to elaborate a set of basic principles relating to admissibility and value of evidence, and certainly written evidence in criminal matters. They prefer to stick to the principle that any evidence may be brought and leave full liberty to the judges to assess the evidence brought. As a matter of example, one could observe, and that is then rather for the witness statement, that hearsay and the conditions of its admissibility have not been defined, which is damaging. It is also the case in national laws, at least continental national laws. It is, in fact, the far West, no rules. On the side of the prosecutor, there is a habit to use press articles and NGO reports as evidence, also videotaped documents. This kind of evidence is mostly not objective and should be strictly regulated, prohibited in many cases. NGOs often have own interests in a conflict. Then I come to my last item, the gathering of evidence, because evidence means gathering of evidence, and its evaluation is essential for both prosecutor and defense. And for, we must state, and this is almost inevitable, I would say, that a prosecutor here, in terms of means and time, has an enormous advance on defense. Defense will never be as well equipped as prosecutors for the task of the gathering of evidence. And gathering of evidence for defense in continental law is as much as inexisting. It is not in the culture of the inquisitorial system. The gathering of evidence is done by the prosecutor. Luckily, in this ICC system, this is not the case. But this, of course, supposes important means in cases of this magnitude. The question of the guiding principle of equality of arms, Article 67, has been observed in the text. There is no doubt that the means of the prosecutor, as I say, are not limited, and there are no rules set relating to possible limits for the prosecutor. This is, however, not the case for defense. The registry has elaborated a set of rules relating to the legal aid system, the Single Policy Document 2013, which is still applicable now, and which restricts severely the means offered to defense under that system. As such, the document contradicts its own first guiding principle of equality of arms. This is not only the case towards a prosecutor, but also towards cases which are conducted outside the legal aid system. In particular, but not only, as to the gathering of evidence, the legal aid system is extremely restricted and restricting, and this installs, in my opinion, a situation of inequality of arms. As I said, in cases of this magnitude, the basic gathering of evidence, which will have primarily to be done in the regions where the conflicts occurred, will clearly have to be done by professional investigators who are native speakers, familiar with the region and the conflict, familiar with legal issues. That is very important. Language is often the enemy of justice, and we know trial situations, for example, Lubanga, where the registry assumed wrongly that there is only one Swahili spoken on the whole territory of the Congo. Swahili is by essence a lingua franca formed on the east coast of Africa. Defense knew that Swahili mixes up with the many local languages and is in Ituri called Kingwana, and is very different from the Swahili spoken in Kenya, where the interviewer came from. The result had been that on videos of interrogations of would-be former child soldiers, the children did not understand fully what the interviewer asked, and vice versa. A correct understanding and speaking of the local language during investigations is consequently of the essence. Before the ICTR, defense under legal aid was entitled to 2 full-time investigators for the whole duration of pre-trial, trial, and appeal, and 1 legal assistant, or 1 investigator and 2 legal assistants. Under the single policy, and even before, at the ICC, at the time of the Lubanga case, the investigations budget was and is limited to 73,000 euros for the entirety of the case. At a monthly gross rate fee of 8,965 euros, this means 8 months of investigation. Knowing that cases at the ICC can last for years, this is absurd and means organizing inequality of arms. One has to realize that when defense starts, the prosecutor's teams have been investigating often since several years, which means OTP has an enormous advantage on defense, not only in matters of time, but only in matters of human resources. Rule 20.1e of the Rules of Procedure and Evidence provide that the registry shall provide the defense with such facilities as may be necessary for the direct performance of the duty of defense. And Regulation 83.1 of the Regulations of the Court provides legal assistance by the court shall cover all costs reasonably necessary as determined by the registrar for an effective and efficient defense, including the remuneration of counsel, his or her assistants, as referred to in Regulation 68 and staff, expenditure in relation to the gathering of evidence, administrative costs, translation and interpretation costs, travel costs, and daily subsistence allowances, which have been left out in the new policy I mentioned. The refusal of the registry to grant full-time investigation for the complete duration of the Lubanga case to defense has been the reason why I have had to leave the case after pre-trial, my allowed investigation time being almost fully spent. It was for me legally and ethically impossible to go on, knowing that I would not get the means to do so. A defense investigation is not limited to find evidence. It must also examine the evidence brought by the prosecutor and or the victims, reason why the presence of the investigator on the hearings, pre-trial, trial, appeal is of the essence. The single policy of the registry consequently violates Regulation 83(1). I remember at the hearing, at the pre-trial of Lubanga, my investigator sitting next to me and the prosecutor bringing a new item of evidence where the distance between two villages was of the essence. And the prosecutor, alleged that a person had made that travel in one day. My investigator sitting next to me said to me, it is impossible to do it in one day between these two villages. There are no roads. There are only paths. So you have to do it by foot. And it takes 4 or 5 days. This is a concrete example of the importance of being assisted continuously by a professional investigator. He was a lawyer of the region who spoke the language and who knew the conflict. And the prosecutor was afraid of him, I must tell you. This discussion about the limited scope of legal aid should be extended to other parts, such as the level of gross fees, wrongly presented as net fees, which are completely insufficient for experienced lawyers having to respond to the criteria set by the court. Also is the obligation to enter an action plan and the approval of an action report a blatant violation of the duty of confidentiality of counsel who never should reveal her or his judicial strategy and certainly not to the court. These rules tend to impose a control on counsel who then stops to remain independent and cannot perform their duties, which are to be independent ethically. This is basic law for counsel. Approval is even needed to free an amount of fees held in trust by the registry until approval of the actions. This is conflicting with the duty of independence of counsel and with the international rule that one should be paid for the work performed. These rules set up by the registry are not acceptable. They also exist only for defense, not for the prosecutor, and consequently organize, again, inequality of arms. Equally, and I'm almost finished here, they mean that defense is severely mortgaged and not fully paid during months, even years. Also, do these rules impact consequently on the means of defense to gather essential evidence? A full analysis of the registry's single policy would bring us too far today. The defense section of ICCBA, however, has studied this document and has produced a paper which criticized the registry legal aid system and its legality. This document should soon be made available on the site of the ICCBA. To conclude, we have to state one, the role of defense is the third pillar next to the prosecutor, and the judges. The third pillar of a trial should get the means to be the third pillar, and to do the investigations, to written evidence, and towards witnesses that are needed, whatever they may be, and without any control by the registrar. A defense should not report on what it is going to do and what it has done. The freedom of defense is capital in trials, and in trials certainly of this magnitude. So the conclusion also is that the means of defense in the present situation are not sufficient, and that the court has an enormous problem here, because this has been the situation ever since Lubanga, as far as professional investigation is concerned. The counsel and co-counsel and also legal assistants are not equipped to do these investigations. I know they do sometimes, but they don't speak the language, for example. They don't know the conflict. They don't know the country. So they need a professional investigator coming from that country, which is difficult to find because it is possible that this investigator has interests, has been part of the conflict. So the quest for this professional investigation is a very difficult one, but it is possible. In Lubanga, I found one. This is my conclusion, that the court has an enormous problem relating to defense and to professional investigation for defense. I thank you.
Thank you, Jean. Our next speaker is going to be another colleague from the Defense Committee, Anna Tukate. Anna is listed as counsel for the ICC and as a member of both the defense and membership committees of the ICCBA. She's also a female Pacific, the only female Pacific Islander listed as an arbitrator with the Court of Arbitration for Sport. She is admitted in the Tongan and Fijian bars. She's a deputy director of the Institute for Small and Microstates based in the UK. She's a fellow with the Forum for International Conciliation and Arbitration. And she is also an arbitrator in the Fiji Employment Arbitration High Court. And in 2017, she was awarded the Medal of Order of Fiji by the President of Fiji for her contributions in this field. Anna, would you like the PowerPoint on from the get-go, or?
Yes, please.
Okay, let's see if I can get this working.
So while John is putting up the PowerPoint, just to recap, thank you so much, John and Sarah. They had covered parts, the three parts in which defense counsel gets involved, which is the pre-trial, trial, and the appeal. And of course, we've heard that it's a mixed process and procedural systems of merging common law and continental law. Sarah had so rightly identified the gaps in terms of the harmonization of both these systems and the need to have a strong independent defense when it comes to fair trial. And that's also the means to deliver our duty as defense counsel. The last presenter rightly talked about the gathering of evidence and investigation issues for those of you that have just joined. And this matters to the defense, especially during cross-examination, which is our topic today, because of the context that we're dealing with in terms of language, the country, even the quality of the investigation. He also presented on the gaps that's been offered to us as defense counsel in the ICC, especially the legal aid system, including its sufficiency. He also discussed the complexity and the resource and time in terms of the fight for equality of arms. What I will just turn is just to focus on issues of cross-examination during the trial period before the trial chamber, just so that you're aware or are reminded of certain issues over case law and the rules of procedure. Can we have the next slide, please, Tragan? As you all know, as defense counsel, we have a right to cross-examine any witness. And of course, our client can be cross-examined by the prosecution. And these are the rules of procedure and evidence before the ICC, which is Rule 140 subsection 2B. What we've been discussing and what's been revealed is the issue on the relevance and other relevant matters that can be brought forward for us as defense counsel and against our clients. Thank you, Dragan. Next one, please. This is the case in trial chamber 10 in terms of the questions of relevance. One thing that the chamber brought out was that if defense counsel is presenting and cross-examining the witness, if the trial chamber, members of the chamber actually have questions for the defense that with regards to the relevance, is that the defense counsel ought to give an answer and try and relate it to not only the nexus, which is the issue in the case, but also the credibility. That comes into being, questions that the defense counsel needs to prepare for during pre-trial phases, the issues of defense confidentiality or the instructions from client when you are presenting a cross-examination issue to the court. Next slide, please. Things to note for us from the common law system, this is quite common with in-camera cross-examination of the links for testimony, live links. Witnesses are still subject to cross-examination. One of the tips that we'd like to suggest is that just do preliminary checks on the links, even the timing, especially when you're dealing with different time zones and the facilities that you'll be facilitating with. Some of the issues that are brought up by defense counsel that are appearing before the ICC are the rooms that are available to defense counsel. In between breaks or in between trial time, we would suggest that you also handle all the preliminary administrative issues and including the support and the financial issues has to be sorted out with the registry. Another thing to note is prior recorded testimony. There are conditions for that. It's in Rule 68, provided that the defense has an opportunity to cross-examine. Sometimes prior recorded testimonies are pre-recorded and then coming to court, the witness can also give live testimony, which the cross-examination will be relevant then. Also, the agreement on evidence for us in the common law jurisdiction, this is called agreed facts. The chamber accepts them as facts, so no need to cross-examine or revisit these issues. Next slide, please, Dragan. I'm just conscious of time and we need questions at the end. One thing that was highlighted by both counsels before me is that this takes years for the case and for the trial to come to the chamber. And because of years of evidence gathering, investigation, so you're dealing with hundreds of documents, you're also dealing with a lot of witnesses. There are times when defense counsel will have new evidence that was not previously submitted into evidence against your client that are coming forward. One thing to note is the conduct of proceeding decisions. Please look at the timelines for disclosure. Some timelines have 24 hours that the prosecutor can give you notice, and some timelines can be negotiated during pre-trial. So we advise to do that. There's also a difference between presenting the evidence and admitting them. There has been issues in certain cases that have been brought before the chamber on presenting evidence during the defense case by the prosecutor that was not disclosed during pre-trial. That was allowed if the prosecutor can establish if it's in relation to credibility, refreshing the memory of your client or the defense witness, and to reinforce evidence that has already been presented. However, when it is the defense case being presented, it'll be on a case-by-case basis in terms of the decisions. Also, John had covered this, the admission of videos and other materials meaning newspaper articles, some of the literature. It will be assessed on its relevance. He rightly talked about the probative value and how subjective it can be and how unfair it can be, so I won't dwell on that, and the prejudicial effect to your client. And I've listed a case there that discusses this very issue. Next slide, please. And I think that's from me on the cross-examination, and I'll hand over to my colleague, and I look forward to answering questions during the discussion time. And I'm very conscious of time. Thank you.
Thank you, Anna. And with that, I would move to Brian Kennedy, our next speaker, who is also a colleague from the Defense Committee. Let me just see if I can get this to work the right way. There we go. So Brian is an American licensed attorney and is a member of the bar in both New York State and Connecticut. He has been practicing since 1991 and is the founder of his own law office in New York, which he started after working as a senior assistant district attorney in New York City for a number of years. Previously, he also worked for the CIA, where he held top secret security clearance. In addition to the International Criminal Court, he is admitted to practice in New York, Connecticut, the U.S. District Court for the New York Southern District, New York Eastern District, and the U.S. Court of Appeals for the Second Circuit. Brian will be speaking to us on the topic of cross-examination. Brian, the floor is yours.
Thank you very much, Dragan. I appreciate everyone showing up to our webinar today. Thank you very much. So I'm going to be speaking about techniques of cross-examination. And I'm going to first detail a little bit of my experience because it does inform how I go about cross-examination. As Dragan said, I'm a former prosecutor here in New York City. I'm sitting in New York City right now. I've been a defense attorney for over 25 years. And as of last year, I'm now on the ICC listed counsel, and I'm also a co-defense committee member with others on this webinar. So my presentation today is going to be a little bit more practical, kind of a roadmap of what you can do in cross-examination. As the other speakers have already told you, my understanding is that practitioners in the civil law system, the continental system, have very little or no opportunity to gain a familiarity and to learn the art and to become adept at cross-examination of adverse witnesses. As has been said, the civil law system is inquisitorial. So it's the judges who take the role of questioning witnesses. My entire experience as a litigator has been in the United States. And here we have the common law system. So by its nature, it is an adversarial system. Attorneys here have frequent opportunity to engage in cross-exam of adverse witnesses. And as has been said by the other speakers, the ICC is a hybrid model. So it meshed these two systems together. Again, I'm going to stick to more practicalities, but there is some but scant authority for cross-examination. Already, Jean talked about Article 67 of the Rome Statute, which is entitled Rights of the Accused. Section 1E says, in the determination of any charge, the accused shall be entitled to a public hearing having regard to the provisions of this statute, and to a fair hearing conducted impartially, and to have the following minimum guarantees. Under subsection C, that says to examine or have examined the witnesses against him or her. Then it further reads, the accused shall also be entitled to raise defenses and to present other evidence admissible under the statute. Anna talked about the ICC rules of procedure and evidence, in particular, Rule 142B. So that's kind of scant authority. So how do you go about it? How do you exercise this right? Practically speaking, well, from where I stand, there is nothing more challenging. And to be quite candid, there's nothing more fun being a litigator than cross-examination of adverse witnesses. It is certainly an art. People are not necessarily born with an argumentative or cross-examination style, but it can be taught and it can be learned. Cross-exam allows you to punch above your weight as an attorney. It allows you to poke holes in the prosecution's case, and it allows you to support your defense theory. After a while, one adopts a certain style. And this does take years. It should be something that feels natural and authentic and earnest. I think I've developed a personal style, and I'm going to call it the Jimmy Stewart style. And I know we have a lot of attorneys all around the world who may or may not know Jimmy Stewart. Jimmy Stewart was an old-time Hollywood actor. He had a reputation for sincerity and for decency. He had a very laid-back kind of attitude, but sometimes he had an edge. And there's a great movie, 1959 black and white movie called Anatomy of a Murder, where Jimmy Stewart played the defense attorney in that case. Fantastic movie. Now, do I model myself after him? Not really, but after years of doing this, that's kind of how I come across. So cross-examination is one of the greatest engines of truth. It allows a party one of the most important rights that an accused person has. And specifically, that's the right of confrontation, to directly confront your accuser. In my experience, there are 4 components of effective cross-examination. Now, number 1, and I think this might be the most important component of cross-examination: prepare thoroughly. That means reviewing sometimes thousands of pages, tens of thousands of pages. And I've had cases where there are hundreds of thousands of pages where it was physically impossible. I needed a computer program to help me, but you have to do it. Every witness statement, every recording, every law enforcement report, every medical or scientific report, you must look at every single document, because cases frequently come down to just a handful of pages. There's a famous golfer who said, "The harder I practice, the luckier I get." And that's true in preparation. You must prepare and then be ready with what you've gathered and assembled for cross-examination. Yes, it is excruciatingly time-intensive and laborious, but you must pull these few documents together, the ones that you cull out as the most important documents, and categorize them and have them ready for marking as exhibits for cross-examination. The second component of effective cross-examination is to select the right witness to cross-examine. Now, in my experience, I cross-examine almost every adverse witness. But the amount of time that I spend varies greatly. There's a reason for this, because you have to be careful of certain witnesses. You must be careful of a child witness. You must be careful of a sympathetic witness or a highly trained or experienced witness. Sometimes with those kinds of witnesses, you limit your question. Most times you just question those kinds of witnesses to buttress the strengths in your defense theory rather than impeachment of those witnesses. The third component of effective cross-examination is to understand the purpose of cross-examination. Now, I think there are 2 purposes of cross-examination. A is impeaching the credibility or reliability of a witness. Credibility means, did that person, that witness, observe the crime? Is the witness exaggerating or lying? That's credibility. Reliability is different. Reliability is, could that person witness the crime? Did the witness need glasses? Was the witness a far distance away? What were the weather conditions? Were there any obstructions? That's all reliability. Now, the second thing, the second purpose of cross-examination is to support the defense theory of the case. Now, let's talk about impeachment of witnesses on cross-examination. It can address several different factors, and the list that I'm about to go through is non-exhaustive. But when you're cross-examining a witness, you should be prepared. You need to know who that witness is and seek whatever you can to know about that witness. Number one, the witness's reputation for dishonesty. Now, in this kind of line of questioning, there's usually no extrinsic evidence allowed to prove up that a witness is dishonest. Number two, a witness's prior criminal conviction. When that witness has placed his own interests above the interests of society. Number three, as a factor for cross-examination, is the witness's bias, such as a relationship that that witness has to any of the parties, or a grievance that that witness might have toward one of the parties, or an affinity that that witness may have toward one of the parties. Number four, the witness's financial motivation or other self-interest, which is especially true for experts who are paid by parties to testify, and quite frankly, are sometimes in the pocket of parties in providing their testimony. Number five, a witness's fear or intimidation by a party to the case is definitely something to explore. Number six, a witness's failure to timely report an incident or an inculpatory or an exculpatory fact. Why did the witness delay in coming forward? Maybe it's manufactured evidence that witness is now presenting. Number seven, a witness's intoxication or impairment by drugs or by alcohol, which would affect the witness's ability to perceive or to recall or to relate an event. And number eight, and I saved this as best for last, the prior inconsistent statement or omission. And personally, I have found this to be the most powerful tool. And the reason why it's a powerful tool is because usually you are confronting that witness with a piece of paper. Sometimes pieces of paper are more powerful than testimony. So let's talk about prior inconsistent statements or omissions. There are many authors who have written on this point on cross-examination. One is, in the US anyhow, is two practitioners, Dodd and Posner. They're longtime defense attorneys, and it's an excellent book. They wrote it in 1993. It's an excellent book for anybody wanting to learn about cross-examination, in particular using prior inconsistent statements or omissions. Now, there are 3 C's, the letter C, for utilizing this as an impeachment tool, the prior inconsistent statement or omission. So, A, have the witness confirm or repeat the testimony that you want to impeach. So, for example, you would say, today, Mr. X, you said in your testimony the following. That's confirming or repeating that testimony. B, you want to credit a prior statement made by that witness to establish that a prior statement was reliable or accurate. If it was the prior testimony, you want to ask that witness, well, where were you when you talked with law enforcement, for example? When exactly did you provide prior testimony for this case? Then you ask if there was a court stenographer or some recorder present to memorialize the prior statement. Then you ask the witness, did you take an oath to tell the truth? And were you informed that you would be subject to the penalties of perjury? Ask the witness then, have you had an opportunity to review your prior testimony for accuracy? Now, the reason why you're doing all of this is to, again, to build up that prior statement, to credit it. Now, if this prior statement was to a law enforcement officer, you would ask the witness, where were you when you made that statement to a police officer or law enforcement officer? Ask that witness if that time period that the witness gave that statement was closer to the event, and whether that makes it the recall at that time fresher in that witness's mind. Ask the witness, did he intend to provide an accurate report to that law enforcement official? Again, you're building up that prior statement. And then the final C is confront the witness with the prior inconsistent statement. Now, it is important that you must use the actual words of the prior statements. If it's a deposition or a testimony, you must include the question and the witness's statement in response. And then you ask if this witness can admit to making the prior inconsistent statement. Now, the witness is going to do one of two things. The witness is going to say, yes, I made that prior inconsistent statement. Bang, move on, you're done. Okay? The witness might say he does not remember, or he may deny making that prior inconsistent statement. And if so, the use of extrinsic evidence is permissible. So you need to have that prior testimony, that prior transcript, or the affidavit ready to go. And you will use that to confront the witness. Likewise, a witness's omission to state a material fact may be used to impeach the witness. However, you can only use omissions if that omission or material information was brought to the attention of that witness, or should have been brought to the attention of that witness at that prior time, and the witness failed to mention it, and it would have been natural to mention it in the prior statement. Now let's talk about the fourth component of effective cross-examination. You must cross-examine effectively. The bottom line with cross-examination is that the court has jurisdiction and or discretion rather to bar questioning. And so if you try to bring up collateral matters, if you try to bring up irrelevant matters, if your tone is demeaning or too argumentative, you could very well be shut down. Furthermore, you should have a good faith basis for your line of questions, but be sensitive to the court's feeling about this and make sure your tone is not too aggressive. Be prepared to explain to the judge why your line of cross-examination is relevant and central to your case. Usually in cross-examination, for it to be effective, you want to go just one step at a time. You want to elicit one fact at a time. You do not want to use compound sentences. In cross-examination, to be effective, you should use very short, very clipped questions. And many times in cross-examination, you're only seeking a yes or no response. You don't always have to know the answer of the witness, although you should, but not always. Sometimes you can fish a little bit. And many people have heard that in cross-examination, you never ask a question you don't know the answer to. That's usually true. But again, cross-examination is an art. And I've had some wonderful results, not knowing what the answer of my question was going to be, but leading the witness to somewhere and then getting a wonderful response that I can use in summation or for the benefit of my defense theory. You never want to lose control of the witness. If the witness rattles on and on and on with an answer, you might say to the witness, do you remember what the question was? And ask him to answer that question. So there are, again, it's an art. There are ways to prepare for cross-examination. This is a very practical experience. Many lawyers have a notepad. They employ what's known as the chapter method of cross-examination. And they will write down on one piece of paper a certain category of cross-examination that they want to go into. Some attorneys like myself, I draw a line down the middle of the page and I put the witness's testimony, not necessarily word for word, because I can't write that fast, but a synopsis on the left-hand side of the page. And on the right-hand side of the page, I write notes to myself. Cross-examine on this, cross-examine on that. That's a practical way of going about it. Now, there's no one tried and true method in how to actually prepare for cross-examination as you're sitting there waiting to cross-examine. But that's the approach that I've found very helpful. So I want to thank you all for your time, and I'm going to turn it over to our last speaker. Thank you.
Thank you, Brian. And indeed, we are now at our last speaker who, oops, I lost him on the chat for some reason. There he is.
I'm here.
And I'd like to spotlight him. There you go.
There we go.
Our next speaker is Mr. Thomas Knief. He was admitted to the bar in the state of New York in 2001 and is a founding partner of the firm of Razor and Knief PC and is one of New York's preeminent criminal defense attorneys. He previously worked as an assistant district attorney in one of the most prestigious offices in the United States, where he tried hundreds of criminal cases and earned a reputation as a skilled litigator. Tom is also a commissioned officer in the Army National Guard's Judge Advocate General Corps and a veteran of the Iraq War, where he earned the Army Commendation Medal and the Global War on Terror Expeditionary Medal for his outstanding service in a combat zone. Tom represents soldiers charged under the Uniform Code of Military Justice. Most recently, he served as Military Senior Defense Counsel, supervising the defense of all accused soldiers of the New York Army National Guard. He's a recipient of the Distinguished New York State Bar Association's Award for Excellence in Public Service and has been recognized by U.S. News and World Report as one of the best lawyers in America. Today, Tom will be sharing insights into cross-examination with us. So, Tom, I give you the floor.
Well, thank you. Thank you so much for that introduction, and thank you for having me.
We've lost your video. We've lost your video.
Let's see. Oh, there we are. There I am. Okay. Now I get to look at myself while I speak. Anyway, thanks very much for the introduction. Thanks so much for having me. In some ways, this may be anticlimactic because Anna and Brian, I think, have spoken so eloquently already on the mechanics of cross-examination, the foundations of it, that I don't know that I have all that much new insight to add, but I will try to add what I can. First of all, if you haven't got the point already, and I'm quite sure our attendees have, there's really no way to overemphasize the importance of cross-examination in an adversarial system. It is so important that the founding fathers of our country, the United States, felt it necessary to embed it in the Sixth Amendment of the first 10 amendments of our Constitution, which of course is our Bill of Rights. And of course, as most of you know, in the United States, we've got our system, inherited our system from English common law. And it's important, centrifugal really in any adversarial based common law system. To read you one quote that is often quoted in American case law and perhaps beyond by a celebrated legal scholar of the 19th and 20th century, John Henry Wigmore, whose treatise Wigmore on Evidence for over a century has been considered the gold standard of evidence in our system. Cross-examination is the greatest legal engine invented for the discovery of truth. It is so important that I would submit that you cannot practice in an adversarial common law-based system that has cross-examination like the ICC does effectively without mastering it. It's what in the military we refer to as service disqualifying. The good news is, although it is referred to as an art quite often, and that's an apt title in many ways, in other instances it's referred to as a skill. There's another very preeminent legal treatise called the Science of Cross-Examination. I prefer to refer to it more as a skill or a science. And the reason I say that is the term art implies that it requires a certain level of talent, or there's something ephemeral about it that only maybe certain people that possess certain gifts can master. That is not the case. The reality is that any of us, using some of the skills that have already been touched on by Anna and Brian, can master it. And to me, that is why it leans more towards a science, the idea that you can apply a certain method to it, do it repetitively, do it systematically, and be efficient at it. And that is the truth behind cross-examination. There's another part of that quote, though, from John Henry Wigmore that is less often cited, but in my opinion, every bit as important to understanding the significance of cross-examination. So after Wigmore said cross-examination is the greatest legal engine ever invented for the discovery of truth, and in my opinion, certainly in this type of system, that is true, it's undisputable. He goes on to say, you can do anything with a bayonet except sit on it. A lawyer can do anything with cross-examination if they are skillful enough not to impale their own cause upon it. And that leads me to my first point about the craft or the skill of cross-examination. And it really has to do with the idea that as important as it is and as essential as it is, and as much as anyone can master it, if there was one thing that I would encourage every lawyer to keep in mind is the maxim, sometimes expressed, less is more. In the American system, because as you may all know, that baseball is our national pastime, you often hear the term base hits, that in conducting a effective cross-examination, what you're trying to do is get base hits. And for those who don't understand baseball, the premise is that a baseball game can be won not necessarily by hitting the ball over the fence or hitting it the furthest, which of course may get the crowds all riled up and make great for a great Hollywood drama. The overall war, the overall game, if you will, is won by putting runners on the bases in whatever undramatic way you can do it, and ultimately tying an inning together, tying a series of innings together, and bringing those runners home. What that translates to in cross-examination is your primary method is to ask small, non-compound, yes or no questions that on their surface, probably most, if not all, seem very innocuous. And you control the witness by, one, with rare exception, posing to them only yes or no questions. There was something mentioned earlier about how the truth can be many different things to many different people, and that's true. But what you're trying to bring out as the inquisitor, if you will, on a cross-examination is the version of truth that supports your case, your client. And the way you do that is not by giving a witness free rein to editorialize or color or add their narrative, but to require them to answer yes or no. Now, of course, what if they answer yes or no, and it's the opposite of what supports your case? You're looking for a yes answer and they give you a no, or vice versa. Well, the way you control that, and this is something that I think Brian touched on quite adeptly, is you want to prepare and enter that chamber, that cross-examination exercise, if you will, armed with as much evidence, as much facts, as much resources as you can possibly mine from the case itself. Best way to do this, of course, which has also been touched on already, is in a circumstance where a witness has testified previously regarding the same matter you're cross-examining him or her on. When you have sworn testimony, you have what, in fact, I have a transcript right here that I was just going through, and this is called a punishment book. This is what Brian was speaking about with impeachment, because now you know for certain the questions you can ask that witness, because you can take them from the prior transcript, ask them essentially the same way, and should they give you a different answer, they're actually hurting themselves and the prosecution's case more than you can ever hurt it, because now you can redirect them back to their prior sworn testimony, and you're going to, in all likelihood, make them out to be at minimum an unreliable witness, or more importantly, as we've heard already, an incredible witness. Now, what happens in circumstances where you don't have prior sworn testimony of the witness, which you don't always have? Well, there's other ways that you can mine the materials you need to put together an effective cross-examination, knowing that you have a strong likelihood of getting the type of answers, or the type of yes or no answers that you're looking for, to get the witness to give you the answer that you're looking for. The other, I would say the second best material is prior statements of the witness. And notice I didn't say prior sworn statements. There is all sorts of evidence in a case where a witness may have said something, said it in an interview to an investigator, said it in the press, said it in a document they had filled out. And while you may not be able to do the same method of impeachment by a prior inconsistent sworn statement, you can certainly confront.
Something appears to have caused a technical difficulty. We'll wait a little bit to, hopefully the issue will resolve itself.
The point is still made for the finder of fact. Can you guys hear me okay, or am I breaking up at all?
You were breaking up and now you're back online. So it's froze for about a few seconds.
Okay, is it okay now?
Yes, it's okay now.
Okay, sorry about that. I don't know if it's my internet connection. And I would say that the third, aspect of how you can go about doing this is, there are certain incontrovertible facts that you can confront a witness with, right? What the weather that was like that day. Other material that you can have a reasonable likelihood that they're not going to be able to wiggle off the hook on, as we like to put it. And then finally, there are circumstances where you're going to have to ask the witness questions that you don't know the answer to. There is a risk involved in doing that, but like anything else, you have to manage that risk. And that's when more of the experience and intuition may come in, and less of the science per se. But that's also part of part of our job as attorneys. I know Brian touched on before the chapter method. I'm a big believer in that because it helps us set out a roadmap to a cross-examination before the cross-examination begins. And what the chapter method looks like, how a specific attorney applies it and so forth, there's all different ways. But generally what it looks like, and what it looks like for me, is I find a main point. I break down the main points that I'm trying to get from a witness during the course of a cross-examination. I'll write them out in a trial notebook, not word for word, but I'll put the subject, like the chapter of a book, a title. And then rather than coming out and asking them that ultimate question, whatever it is you're trying to get at in that chapter, which, if you confront it, if you present it that way, you're more likely to get a witness that may give you the answer that's different from what you're looking for. But if you break it down into a series of smaller questions that really, without the witness disentangling themselves from, any sense of credibility, they're going to have to answer in the way you want them to answer. By the time you get to the ultimate question, what the title of your chapter is, they're really going to feel compelled or just be compelled to answer that ultimate question in a way that you want them to answer it. And, if you have a circumstance where, the witness is just going to be, completely uncooperative and, in the face of all logic and reason, give you answers that, don't fit the narrative and just don't make sense, well, then, they're not going to fit the narrative. They're not going to make sense to the finder of fact. And in some ways, you've accomplished what you came to do as a result of the witness's lack of cooperation, hostility. Because ultimately, if it's that blatant, they're going to look silly. I can tell you, I can say that in my experience, and having examined hundreds, maybe even thousands of witnesses, the vast majority of witnesses, even witnesses that we might otherwise put in the hostile category, are not going to do that. What drives most witnesses' testimony, and this is particularly true of law enforcement witnesses, is a resolute, absolute fear of testifying. It's often said, at least in this part of the world, that people have a greater fear of public speaking than they do of death. It's not true of lawyers, right? But for most other people out there, for whatever reason, police officers, cops, as we call them here, law enforcement officers, so forth, seem to have the most pronounced fear of testifying. And really what it is people don't want to look silly. They don't want to be embarrassed. That gives the lawyer a tremendous amount of control over the cross-examination, even of difficult witnesses. And it's one of the reasons why, going back to Wigmore's quote, it is the most, reliable, greatest engine for the discovery of truth that we know. Now, what happens when we have one of those exceptional witnesses, one of the, witness that you just know is going to be absolutely hostile to you, a single accuser case? We see this here a lot of times with our government prosecutors. We use cooperating witnesses, which really means they find another criminal, someone who is criminally involved as your client, or perhaps more so, turn them into a state's witness or a government witness. They're doing it because they're trying to get the benefit of unraveling themselves from their own criminal problems and avoiding their own protracted jail sentence. And they're basically a hired gun, similar to an expert, and they're there to torpedo your case in whatever way they can, because that's the only way they're going to get the credit they want from the prosecution. Or, it doesn't have to be a cooperating witness. You can find this in a vindictive witness, someone who's perhaps fabricating a sex assault to extract vengeance on your client, with which certainly I've seen in many instances. And you can't necessarily rely on the fact that they're going to be so scared to testify that they're going to tell you what you want to hear, or that they're going to be disciplined witnesses or cooperative witnesses in the sense of answering honestly and earnestly on cross-examination. What I would say with respect to those witnesses, more often than not, you want to consider staying away from the facts if you have a truly hostile witness. And instead of asking them about the facts of the particular case and so forth, particularly if you don't have lockdown, impeachment material based on prior transcripts and so forth, is you stay away from the facts and you focus on their bias. Okay. And I've done this, and many experienced attorneys will do this regularly. We have the prosecution's fact-based witness, the one that's going to bury your client by saying your client did this, your client did that, and piece the whole case together. And they literally get up there and conduct a cross-examination, and you don't ask them anything about their account of what happened that night and so forth, but merely focus exclusively on all the things, whether it be a cooperation agreement with the prosecution, whether it be their absolute animosity towards your client, which you can bring out in the same way we talked about bringing out other questions on cross-examination, using the chapter method, doing a thorough case investigation, and so forth. And you show them to be not necessarily an unreliable witness, but an incredible witness by, again, bringing out that bias. I know we went on for a while, and I think I've spoke for my 15 minutes. So that's really all I had. And again, I think that in many ways it probably echoes what has already been said already, but I thank you for the opportunity. Obviously, if there's any questions, I'm happy to try and answer them.
Thank you for that. And again, we are now at the question and answer portion of today's webinar. I am following the chat in both the YouTube and the Zoom environments. And so if you do have a question, you can type it in the chat or use the raise hand function in the Zoom to ask your question personally. We already have a few questions that have been submitted in the chat. So I will present these to the speakers and see if anyone has any contributions to make with respect to it. So the first one is a compound question. How can a potential conflict be addressed when applying both inquisitorial and adversarial systems in cross-examination in the ICC? Because under the adversarial system, there is this principle that states that the court cannot do what the party fails to do for himself in court. The method of asking questions by the judge in an inquisitorial system can fundamentally help the prosecution or defense's case. How can this be cured in the ICC while acting as a hybrid court? Would anyone like to tackle that question from the speakers?
Sure, I'll tackle that.
Okay.
So, as we talked about, the ICC uses this hybrid system. So defense attorneys are meant to confront witnesses and to cross-examine them and to somehow gain nuggets of information which they can then use in their summations. Well, what happens if the attorney's not up to the task and the judge doesn't step in? That happens. And so here in the US, trials rely very much so on competent defense attorneys. That's why defense attorneys that handle the serious cases really should be experienced and skilled. However, having said that, I have seen here in the US, when I was a prosecutor in New York City, I did see a judge take over a cross-examination of a defendant. And apparently the judge thought that the district attorney was not doing a very good job. And the judge took over the cross-examination herself. And I saw the judge slice and dice the defendant on the stand, who was a crumpled mess by the end of her cross-examination. So yes, it does happen that judges will step in. And maybe that also, I think that would happen at the ICC as well. And incidentally, that same judge that took over that cross-examination and destroyed the defendant later ran for district attorney in New York City. So now you know what her bent was. Anyhow, I think that both attorneys and judges can cross-examine at the ICC. So I don't see the conflict.
Okay, great. Anyone else have any contributions with respect to that question, or should we move on to the next one? Okay, so the next one is asking for more of a comment from the panel. So I'll paraphrase it, and it talks about how at the ICC, the cross-examination techniques must be adapted to different types of witnesses because of the speed of or the things that are different from American trials, such as that the cross-examination is less effective when you have to wait for translations or objections to occur. So does anyone have any comments on how the cross-examination technique can be adjusted to account for these international courts where you have multiple languages being spoken and delays caused by the waiting for the translators to complete the translation of the questions and the answers?
I could try to speak to that, or
sure,
unless somebody else wants to. So, practicing primarily in New York City, it's actually quite common to have translators standing between you and a witness on cross-examination. Either because, for the obvious reason that the witness doesn't speak English as their primary language, or maybe they speak it, but they want to make it sound like they don't understand as much as they do, or because obviously there is a comfort that can come to a witness in slowing down the pace. What I would say is, if you follow the techniques and treat it as a science and have your roadmap, it shouldn't be an impediment. Yes, there are times where you want to kind of throw off the tethers and the reins, put your script aside, and really get into a back and forth with that witness because they utter something that is you can capitalize on and go to town on, like Brian was speaking about, that judge taking over cross-examination. And it can be more stilted to do that through a translator, of course, because perhaps they have a little more time to recover, when you're machine gunning those questions out at them, yes or no, yes or no, yes or no. That's just a reality, but it's not an insurmountable one. And you adjust to it and adjust your pace to it.
I would like to add something.
Go ahead.
Yes. So I'm currently in a case before the ICC, and so I practice also as well in France. And what is striking before the ICC is that there's certain rules. It's very slow. It's you have to observe it's the 5-second rule. You have to observe a pause before speaking. So there's a need of a brief, 5 seconds pause between a question and an answer. So it's not like bam, bam, bam. No, you have to wait, and you have to talk as well, speak clearly and slowly, because there's the interpreters who are always translating either in English or French, which are the two official languages before the ICC. So what is really striking is that you have to be really calm. Really, it's really a slow pace, and to answer, there's maybe for the previous question, you have to make objections, and when you want to do an objection, you have to just stand and say, to the president, you have to wait to have to be able to speak, and you cannot just stop the other parties in mid-sentence, or just say objection and just wait to have the time to answer and develop the objection you're giving. I hope I gave all the information needed.
There are no wrong answers when we're answering questions.
Can I add something also?
Go ahead, John. Yes, John.
We are touching here one of the main problems at the ICC, and that is language. Language is a problem in any justice. I remember a criminal case. My client was a doctor and was prosecuted for having committed a mistake, and the child had died in course of the surgery. In the expert opinion had been written in one of the national languages, French, and in the original French opinion, my client could be considered as innocent. But in the translation to Flemish, because the case was brought in the Flemish language, my client was guilty. Because I'm a native speaker of the two languages, I had that advantage. So I could control the translation and convince the Court of Appeal that there was a major mistake in the written translation. The problem in cross-examination at the ICC is that we are confronting the fact most of the cases are African cases, but also other cases. And in Africa, the amount of native languages is enormous. For example, only in Congo, it's really an enormous amount of languages. And to find professional interpreters, because there it is interpretation, immediate interpretation, who speak the concerned language, which is brought by a witness in all the nuances and details, will be very difficult. And that is really a big problem, I think. It's impossible for the council, of course, to control the translation. Eventually, you will have, as I said, an investigator present at the hearing who speaks the language, and then the translation he will be able to control the translation. But in most of the situations, that will not be possible. So it's a problem, enormous problem. Thank you.
And to answer Jean, for the transcript, after a hearing, so before the ICC, the case is recorded and you have a delay just to correct the transcript. So, and usually in front of the ICC, you are in a team and there's usually a person who has to be very aware of the translation. So into the two official languages, which are French and English. That's it.
Yeah.
Okay, and I think we have another question that I noted down. As his own witness, is the prosecutor allowed to confront his previous statement made during investigation?
I will answer. What is forbidden for the prosecutor is leading questions. So if he has a hostile witness, it becomes difficult. So he still cannot ask leading questions.
So I think, Dragan, the question is that, if a defendant takes the stand on his own behalf, can the prosecutor cross-examine that defendant as a witness? Yes, absolutely, because the defendant places his credibility at issue by taking the stand. So absolutely, the prosecutor can confront the defendant and use that defendant's prior statement against him.
And I think there's a follow-up from the same person asking if the prosecutor has to declare the defendant a witness hostile prior to using their prior statements.
The quick answer is no. It's understood that obviously the defendant is an adverse witness hostile to the prosecution. So there's no ruling needed beforehand.
Okay. And I'm being reminded by one of our chat participants that at the ICC for the translation issue, since oftentimes we know who the translators are, especially if you have cross-examination that will have very scientific or complicated language, you might provide them with some key terminology on paper beforehand so they can recognize it and translate it quicker when it arises in the examination. Okay, the next question that I see in our Zoom chat is, does focusing only on the bias of a hostile witness not act as a limit to our cross-examination? One of the aims of cross-examination is to elicit facts not disclosed by a witness.
So I think that might have been a reference to part of what I said, so I'll try to answer that. Look, of course you're limiting, if you're not asking questions about the facts of a hostile witness, you're certainly limiting yourself in some way. But it's a tactical decision. If you're going to ask facts of that witness and based on their hostility or based on perhaps that their version of the facts or some of the versions of the facts that are going to come out through that questioning are not favorable to your client, you're making a strategic decision at that point. To stay away from the facts with that witness, in the sense of, let's say, a cooperating witness. Both Brian and I have a lot of cases where we handle against the Southern and Eastern District prosecutors for federal crimes here in the United States. And to understand what that means, they're considered the most preeminent federal prosecuting offices in the country. It's a stepping stone, for attorney general and national politics, and they're very well resourced. So if we have a case where we're going to have confronting one of their cooperating witnesses, who one is not a good person, or else they would never be a cooperating witness, because it's almost a prerequisite that you're a criminal yourself. They're going to be thoroughly prepared, practiced, managed, so forth. You're very unlikely to get a rendition of the facts out of them that is any way going to help your client, either because the facts just don't help your client, or they're going to testify in a way to present them in a poor light. In that case, or in many situations like that, you're making a strategic choice to say, look, I'll go into the facts with someone else or with another witness. And with them, I'm just bringing out the fact that they are a biased, interested, bought, sold, paid for witness, and make that clear to the jury, because that, or the finder of fact, whoever they may be, because that has a better chance of making them turn off to whatever it is they're going to say, rather than lead them down, a fact-based cross-examination. Of course, if that witness also has facts that you're reasonably confident you can bring out, they're going to help your case, your client's case, then you bring them out as well. But it's a lot of these are tactical decisions.
Right, and let me just follow up with, you need to sequence your cross-examination. And by sequencing, what I mean is when you're asking particular questions. So with that kind of a witness that has bias or prior convictions or some sort of self-interest, what I want to do with that witness is elicit responses that support the defense case first. Get all the good facts, all the facts that are good for the defense, get them all up front. And then destroy the witness. And then point out the bias or the self-interest or whatever it is. So sequencing is very, very important.
Okay, thank you both for that. Anyone else have any comments on this question, or should we move on? Okay, we do have a question that I'll ask it, but I think it's beyond our remit. It says the ICC does most cases in Africa. There are many cases that are in Western countries. Why haven't these cases been taken? And I think I've heard other speakers in other lectures talk about how the cases are sought to be heard before the ICC based upon complementarity. But I think that's beyond the subject matter of today's discussion. So unless anyone has anything to add on that, I would move on to any other questions that people have. Okay. So this is the final call for anyone who may have a question on either the Zoom or the YouTube side of things. If you do have a question, please type it in chat now or use the raise hand function to alert us to the fact that you have a question, and we'll address it to our panel. And we'll wait just a few more seconds to see if that urges anyone or prompts anyone to give a question. And then I'll check also on the YouTube side of things to make sure that they are equally represented here. Nothing on that side. And just to double check, nothing on the Zoom side. Well, I think that does it for today's lecture then, or webinar. So thank you first and foremost to all of our presenters for your time and your contributions. And thank you to the viewers for joining us for this webinar. And if you're interested in the work of the ICCBA, please check out our webpage and check out the details there. On behalf of the ICCBA and on behalf of the Defense Committee of the ICCBA, I thank everyone and wish you all a very pleasant rest of your day. Thank you.
Thank you.